Welcome back to the Laws of Andrew, and today we're diving into an important topic that everybody has come across at some point in time: legal contracts. Whether you're a business owner, contractor, or freelancer, or just dealing with personal agreements, contracts are a crucial part of protecting yourself legally. But here's the catch. Most people run into problems when preparing and entering into contracts. Let's go over 7 common issues that I see all the time and how you can avoid them. And I can confirm that these issues show up in the most simple contracts, like a promissory note with your cousin, to very complex contracts with sophisticated parties working a big deal. Issue number 1, lack of clarity. One of the biggest mistakes people make in preparing and entering into contracts is using vague or unclear language in their contracts. Legal words and phrases, or what can be referred to as legalese, can be tricky. And if the terms aren't clear, it can lead to misunderstandings and disputes. For example, if you're hiring a contractor or consultant to perform a task or complete a job, don't just say work must be completed quickly or diligently. Instead, specify an actual deadline, like work must be completed by March 30th. The clearer the better, and you can always build in other leniencies if need be, like providing extra time for unforeseen delays. Issue number 2, missing key terms. Another major issue I often see in legal contracts is leaving out essential contract terms. Who's responsible for what? What happens if someone doesn't hold up their end of the bargain? These details aren't written down. Enforcing the contract later can really be a nightmare. Make sure to include payment terms, timelines, deliverables, and what happens if either party breaches the contract. And there are many, many ways a party can breach a contract. So try to think of them all and anticipate these issues beforehand while writing the contract. It makes it much simpler to navigate to the appropriate resolutions if things go sideways later on. Issue number 3, not reading the fine print. Most of us have clicked I agree in what I'll call an online click-through agreement without reading the terms and conditions. Yeah, most of us are guilty of that because we can't be bothered to read page after page of terms and conditions to be able to use our iPhone app to place an order at Starbucks. But when it comes to an important contract and not your triple shot caramel macchiato order, skipping the fine print can cost you big. Hidden fees, auto renewal clauses, or even waivers of rights could be lurking in the document, and oftentimes are. Always read the full contract when it's something of importance to you or your business. And if something seems off, don't just accept it and sign. Ask questions or consult an attorney, at the very least to put your mind at ease over the concerns you felt. Issue number 4, relying on verbal agreements. In the world of agreements between people, a handshake deal might seem convenient, but it is risky. Verbal agreements can be extremely difficult to prove in court. It inevitably becomes a he said, she said situation with no clear answer. So you better hope that you come across to the judge, jury, or arbitrator as more credible than the person arguing against you. Even if you trust the other person, always get agreements in writing. It doesn't have to be complicated. These can be done in a simple email that outlines the terms. This will be so much better than nothing because although it will lack all the formalities of a full-blown contract, it will still count as a written instrument evidencing the agreement terms between the parties. These simple emails that memorialize terms of an agreement can make or break your outcome from any dispute over the matter, and they require very little time to do, so you may as well do it. Issue number 5, not considering legal requirements. Certain types of contracts are more strict than others when it comes to enforceability, and they need to meet legal requirements to even be valid. For example, real estate contracts often have to be in writing to be upheld. Other types of contracts are prohibited by law from including certain elements, such as an employment contract that does not permit someone to stop working and quit. There are federal and state laws that govern these type-specific contract requirements, so if you're in a specific industry, there might be laws or regulations that apply to your agreements. Research these rules or speak with an attorney to really ensure that your contract holds up in court and the provisions you hope to rely on don't get thrown out as unenforceable, because it does happen. Issue number 6, not planning for disputes. Nobody likes to think about things going wrong in a contract, but what if they do? Your contract should at the very least include a dispute resolution clause. Will disagreements be handled in court, or will you use arbitration or even mediation? Under what law will the contract be interpreted? One aspect of the United States legal system is that each state has its own specific laws in addition to federal laws. And some states will give you a much more advantageous interpretation of your contract than other states. And how about where the dispute will be resolved? You can specify venue or jurisdiction in your contract as well, which can become a hugely important aspect of going through a dispute from both a time and cost point of view. Will the dispute be heard in your home state? How about their home state or somewhere in the middle? The further from home, the more it typically costs. Always remember that. As you can see, planning ahead here can save you a ton of time, money, and stress if something ever goes wrong. Issue number 7, signing without legal advice. This one is an easy one. Many people sign contracts without legal advice, and while not every contract needs a lawyer, like signing an apartment lease, if there's a lot at stake, it's usually worth having an attorney review it. A lawyer can spot hidden risks that you've never seen or heard of before and help protect your interests. This could ultimately save you thousands or more in the event of a dispute. At the end of the day, you can make a judgment call on the importance of the contract and if it justifies budgeting in some legal costs to protect yourself. And there you have it. These are some of the most common legal issues that people face in their contracts. Remember, clear language, essential terms, reading the fine print, getting agreements in writing, following legal requirements, planning for disputes, and seeking legal advice can save you from serious headaches. If you found this helpful, don't forget to like the video, share it with others who might find it interesting, and subscribe for more of these types of videos on business law topics.